But I think, if you're talking about it purely on the merits, looking at it holistically that way reinvigorates what was the second most important thing the founders did, which was to protect us against unrepresentative armed bodies of armed coercion that would single out the people who were not in there and treat them poorly. That's what we did to Protestants and Catholics in the whole history of the English Revolutionary period. They weren't permitted to bear arms, and they then were singled out for discrimination. It's what we did to blacks for most of the nation's history. And it seems to me that, that the Second Amendment is a deeply egalitarian assurance that the organs of armed coercion will never again be unrepresentative.
Professor Neuborne.
So that's it. Thank you. I'm sorry.
The
Grim Reaper did come.
Second Amendment is a very hot topic in the last few years with the Supreme Court, and we're going to find out if it's incorporated against the states. Want to make any predictions or suggest an analysis?
Absolutely, yes. I don't see how it. I mean, I don't see how you can read it with its. No matter what you think it says, it's the second piece of the Bill of Rights. How could you not say it's incorporated against the states as well? It's too important.
Well, let's start with questions from the audience. Please introduce yourself and state your question.
Hi, I'm Fred Ansell with the Department of Justice, but I don't speak for them.
Okay.
My question to you is, when I'm hearing your argument, which is very interesting, I don't think of Wallace Stevens. I think of Learned Hand and his interpretation methods of statutory construction. And I'm wondering if that is implicitly or explicitly something that's going through your mind as a way of interpreting the Constitution, where every word takes meaning from every other word and the structure of the statute. You think it's not the way most judges interpret the statutes today, but certainly the way Hand did. And my other question, I guess the reverse question, is there anything about your theory of holistic interpretation of the Constitution that you think would affect the way judges interpret statutes?
Oh, sure, Professor Neuborne, and then we'll let Professor Barnett respond.
You're very perceptive. I mean, if you hunt and peck, I can't find it in my piece now. If you hunt and peck through my piece, you'll see a citation to a wonderful Learned Hand quote, in which he says that words are not alien pebbles in juxtaposition with one another. I did draw great inspiration from Hand's way of reading text, and I think that it is, and I think actually Justice Souter's approach to reading statutes was very similar to that. He attempted to use the Hand formulation in reading statutes. One can agree or disagree with a particular application of it, but he was deeply involved in the contextual reading of statutes when he was on the bench. And so the short answer is absolutely, you're absolutely right.
Professor Barnett, any thoughts?
Not on this question. I did want to say one thing in response to Burt's response, and that is that it's really a separate issue. And I think in the course of making his response, he, I think, illustrates the value of making a distinction between constitutional interpretation and constitutional construction, which is not a distinction everyone in this room is used to making. And I think one of the advantages of it is it sorts out what we're really agreeing about and what we're really disagreeing about. And the way he broke down the three, could it be used for interpretation, could it be used for construction, or could it be used beyond that, illustrates why it's useful to make that distinction so you can identify the basis of agreement and also exactly what it is you're really disagreeing about, so you're not just talking past each other.
Next question.
I'm Brian Bishop from the Ocean State Policy Research Institute, and at the risk of letting the criminals win, I don't know where the shells to my shotgun are, and I'm really almost sorry in a way that what jumps out from what you said are some of the Second Amendment questions. But one very interesting relation of the formulation of Justice Harlan, you said, I would think...
Could you just step back just a little bit from the microphone?
Sure.
Okay. That's
Probably
better.
don't need it.
That's better. That's better.
Walk away from the microphone.
And, you know, lest my patron Saint Edmund Burke roll over in his grave, I think the folks that went after the Bastille actually had pitchforks to start with, and then they got the howitzers. But the what I'm wondering is, might Justice Harlan have said that reference, for instance, to the Second Amendment by reference to the Ninth, that the right of self-defense, which is not necessarily a right against tyranny, but I think animates some of our discussion, and certainly discussion in state and state constitutions, of a Second Amendment-like privileges, wouldn't that have been a way for a holistic reading to also support the Second Amendment? as an individual right?
Sure, but I think you're doing something that, if I were to do it, Randy would quite correctly call me out on it. You're adopting a heresy for this body. You're adopting purposivism. You say you want to read the Second Amendment as a purposive document and figure out what its deep purpose was and read it to advance that. To do that, you have to ignore the preamble. The preamble doesn't say a people cannot have self-defense without arms. It says that a well-ordered militia is not possible without arms. So unless you, I'm trying to give, to do this as a Second Amendment discussion, I think, you're entitled to ask the question, but I hope that you don't judge my piece by its most controversial application, which is the Second Amendment. There's a great deal more than the Second Amendment in reading it holistically. But even at the Second Amendment, my piece, my construction, attempts to give meaning to both halves of the amendment. Attempts to give meaning to the preamble and attempts to give meaning to the individual rights clause. Most of the opposite readings either privilege the preamble or privilege the individual rights clause. And they do it by saying, well, I know what the real purpose is. And so once I know what the real purpose is, I can excise the text that I think is inconsistent with the real purpose. I don't want to do that. I want to be faithful to both clauses in the text and find a meaning that's consistent with both.
Next question.
Ilya Shapiro from the Cato Institute. I'm wondering how the holistic approach applies, or whether it does, to the rest of the Constitution, that which wasn't ratified in 1789 or 1791.
14th Amendment, for example.
For example, whether that just merely says take this holistic approach and now it applies to the states, or whether there's something else. Do you now read the whole Constitution holistically, or just adding bits and pieces and saying, well, that previous holistic bit just drops out based on, or something else gets added in? Can you elaborate on that?
Well, I mean, you asked two wonderful questions. The first one is, would I try to do this with the text of the Constitution, the 1787 text of the Constitution? And there's an effort in my piece. There is a quick effort at doing that. I think it can be done. These guys were brilliant. The people who drafted this were brilliant. And there is a structure to the text as well, if only we'll look for it. They weren't engaged in a kind of random exercise of, gee, I have a good idea today, I'm going to write it down. And it can help us. It helps us understand federalism. It helps us understand separation of powers if we will only look holistically. Now, I haven't got time to develop it, but it's there. Your second point is, I think, even more interesting, and that is, I think that, and this is something the Supreme Court has done only with the 11th Amendment, but it seems to me they should do more generally, and say that subsequent amendments alter the ethos of the prior amendments because we now have to read everything holistically. So I think you're right. I think you read the 13th, 14th, and 15th Amendments and the amendments generally as a package. And as the amendments grow and the package grows, the holistic reading of the document may change as well. I mean, it's no coincidence that virtually almost every amendment since the 10th Amendment, there are 3 or 4 that are not, are designed to perfect democracy. They're designed to fix something about a structural mistake in democracy. There's obviously the 13th and 14th don't do that, but so many of the rest of it does. And from that, I draw something about the importance of defending democracy in the document.
Thanks. Professor Barnett, any response? Any
no,
thoughts?
the line is long.
Very good. Next question.
Professor Ken Klukowski, the American Civil Rights Union, and I've also published a couple law review articles on the Second Amendment. I'm curious as to how your theory would respond to the following. You reference people waving symbolic weapons in the air because they wouldn't be able to overthrow a government. When Madison spoke in the Federalist about how if a tyrannical regime were to come to power, they would face a militia of 500,000 armed citizens, which in a nation of 3 million was roughly the able-bodied male population at the time. And when we see that those numbers hold true now, that in a nation of 300 million, we have 90 million gun owners, of which fully close to 30 million are former military or law enforcement with formal training in firearms